Hey folks, look at us. We're live in the new TWiL Brick House studio. Coming up on This Week in Law, we've got Evan Brown, Dan Gillmor, Iyaz, Akhtar, and Anna Christian. We're going to talk about Google's real names policy, riling lots of people up. Aaron Schwartz making us wonder whether everything is going to be a cybercrime soon. And Stormtrooper armor is going to be legally for sale next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 122, recorded July 29, 2011. Meet Sue Domonous. This episode of This Week in Law is brought to you by Netflix. Watch thousands of TV episodes and movies on your PC, Mac, iPad, iPhone, or TV instantly. All streamed directly to you, saving you time, money, and hassle. For your free 30-day trial, go to netflix.com/twit. Hello and welcome to This Week in Law, our first episode recorded live in the beautiful new TWiL Brick House studios in Petaluma, California. Joining me here in the studio today is Iyaz Akhtar. Hello, Iyaz.
Hey, Denise. I had to travel all the way from my desk, which is across the studio, to come here.
And we appreciate you making the trip. Also joining us in studio is Anna Christian. Hello, Anna.
Hi, Denise. How are you?
Doing really well, and so thrilled to have you here and to be here doing the show. Finally, we've got Dan Gillmor joining us remotely from Stanford, California. Hello, Dan.
There. How are you doing?
Doing great. Thanks so much, and thanks for bearing with us as we've been ironing out all our technical issues running up to the show here. And joining us from Chicago is Evan Brown. Hello, Evan.
Hey, how's it going, Denise? It's great to be here, and I sure do wish I was there with you all in that great-looking studio. Looks awesome.
You're going to have to come visit sometime soon.
I'll be right there.
Yeah, organize your caseload around that.
Sounds good. I'm all for that.
We need you. All right, so we've got lots of exciting and interesting stuff to talk about this week. A lot of interesting things going on the privacy front, and since we have Dan graciously joining us, I want to start off with some stuff in his wheelhouse, specifically to sort of set the backdrop to further privacy discussions. I want to start with what's been going on with Google and preliminarily, its real names policy, which has gotten a lot of attention this week concerning Google+. And then moving on into what Google is going to do or be doing with allowing access to data entered into Google+. So, Dan, why don't you give us a take, first of all, on the real names controversy and see if we can tie those two things together.
Google has said in the Google Plus service that they want people to use real names or essentially the name that that they go by in everyday life. And there have been a lot of people who have not followed that and who have started accounts with either pseudonyms or organization names and other things. And Google's been canceling a bunch of those accounts. Not always in ways that are transparent in why, or in some cases they're actually canceling people who are legitimately using their names. And it's all a big sort of hassle for everybody because it's still not completely clear what Google's policy is for the long run, but they're working on it. This is a beta system, and I think it's a little early to get too freaked out about it because they do recognize they need to allow organizations to establish presence on Google+, and that they do need to find a way to allow pseudonyms because it's not always appropriate for people to use their real names. There are times when you want to allow people to use pseudonyms, but they're going to be working through this for a long time.
And I think that it's important to clear up the question of whether or not you can use a pseudonym on Google+. They've been going back and forth and revising their policy. The current take, as we get it from Jonathan Zunger, the chief architect of social at Google, is that if your pseudonym is really another name you use, it's okay to use it. But if it's the sort of name you're likely to see on a not-so-nice YouTube comment, it's probably not. The policy gives the basic direction, and the practical hard decisions are made by humans, not by automated processes. So they're trying to allow for a space where pseudonyms can be used, but I guess as Dan mentioned, there are growing pains around all that. Our own Dr. Kiki from TWiL here has experienced some of those firsthand. Iyaz, any thoughts on this?
You know, I've thought about this for a while because people who spell their names differently, a fellow named Brian spelled it with an E, and Google kicked him off. And I'm like, well, my name is spelled really odd, and what if they think I'm not real? Or if there's a singer who also uses my name as a stage name for some reason. I'm still not sure why he does that, but he does. And I don't want them to think I'm impersonating anybody on top of that. So, I mean, when it comes to this thing about potentially getting kicked off of Google+, I mean, it is a service you don't have to use. But if you're on it, you know, if you're spending a lot of time sharing your content there, just to know that you can get kicked off because somebody could arbitrarily just say, oh, your name is wrong. That seems a little off to me. But to have an extra space for your other known names, you know, like if you change your name when you got married or something like that, they can have spots for that, or aliases on there. So I'm not really sure, not necessarily why people are freaking out. I mean, you don't have to use plus at the end of the day.
Right. Facebook has a very similar policy and does require people to use their real names on that service, although, again, it doesn't always happen. Evan, what do you think about this? Is this a reasonable thing for social networks to do, or are there good reasons to allow people to be pseudonymous? Anonymous?
I always struggle with that one too. You know, pseudonymous.
Pseudonymous?
Yeah, but it's always kind of one of those things I always try to have to stumble over that word a couple of times. I mean, this is an interesting way of kind of positioning or bringing to light who really is responsible for whom and who's accountable for whom. And something that resonated with me came from Dan Gillmor's piece. He's in the conversation with us here, from the one that appeared in The Guardian, and I think it appeared elsewhere, back on July 13th, invoking this old adage. You know, he says, as the saying goes, if you're not paying for an online service, you're not the customer, you're the product, and the real customers are the advertisers and those who make money on aggregating all the data. So what I take from that, and I'm not sure this is exactly why Dan was invoking that, and I hope you'll comment on that, Dan. I mean, this makes it seem, or it brings to the forefront of me of like, you know, how much do we have the right to complain as users of these products, you know, for what we might see as arbitrary rules, or, you know, things, regulations on these things that we don't like. Clearly, Google is going to want, in any of these platforms who derive revenue from the gathering of information, they're going to want as much accuracy as possible in these things. So, you know, we're not paying anything for these services. So really, I guess the question for me is, how much should we expect that we have the right to actually complain as to how lenient or how restrictive the service is on all of that?
Right. Writing over at eWeek, Clint Bolton points out that one very practical reason for requiring people to use real names on services like this is because it allows for much more accurate, targeted advertising. Anna, what is your take on all this?
Denise, I was thinking about this last night, and a friend of mine mentioned that, you know, one of the reasons that people use pseudonyms on Google Plus or on Facebook is because they don't want everything that they say to come up in, for example, Google results. When you Google someone's name, if you're a professional, for example, I'm an attorney, if I, you know, represent certain clients, yet I go online and I may have a different opinion that I'd like to express, I may want to use that pseudonym and not have it traced back to me if another potential client were to Google my name. So not that I would be doing something illegal or something that I would be ashamed of, but just something that I wouldn't want to interfere with my professional career. So I think that's definitely one reason in favor. One of the other things I was thinking about is something that Evan just brought up. Yes, it is a privilege. We don't have to use Google+, but again, if you know, for example, either Google Plus or Facebook, if all of your friends, all of your colleagues are on it, and you choose not to be, what are you missing just because you don't want to use your real name?
Right. I bring this up here on This Week in Law because there are some issues out there about the legality of requiring people to use their own names on these services. In the UK and the EU, they have more stringent user privacy requirements than we have here in the United States, and folks are closely examining now whether you can require people to use their real names under those laws. There are also in the United States, you know, varying from jurisdiction to jurisdiction, is the ability to have a name change take place in a very informal way, and to have that be your legal name, despite the fact that you have done very little as far as registering or filling out legal name change documents. And all of this, of course, goes to if you're going to be someone who is doing controversial things online that can get people upset with you, whether it's a government or otherwise, anonymity is a real important thing to be able to have. And Dan, that's where I think this all ties in with the questions that you had for the folks at Google Plus about turning over user information in response to government requests. Will you bring us up to speed on that?
Let me just preface it by saying I think the bias in online communications should be that we should use our own names in general, that we should stand behind our own words, that we should, as readers of other people's or listeners to other people, we should have less trust in what people say if they're not standing behind their own words, while we still preserve anonymity or pseudonymity for the circumstances where it's not just not a bad idea, but actually a very important thing to have. I asked Google a while ago about what their policies were with regard to user privacy and what was being potentially recorded by Google and saved, and then what was being made available to government agencies. I asked in part because they made something of a big deal about the fact that everything is encrypted, that it's HTTPS in your browser, meaning that in theory that it's at least encrypted to the server and then to the person who you're communicating with. The answers I got were, I guess I called it a little bit disappointing because I was hoping for more, but I'm not surprised. That Google is basically saying that, I put it this way, they're not denying that they can record all conversations, video, text, and otherwise. And they're not denying that if they get a valid demand from government that they will turn it over to them. What they did not respond to directly as well was the question of whether they are engineering into this a backdoor for government to have real-time access to people's conversations. Again, they have to obey the law. One of our problems is that our laws, or lack of laws in some cases, gives government way too much power to spy on us. But I was hoping that Google might have an architecture that would be encrypted more end-to-end, and it simply appears not to be the case.
Right, and I think that I wasn't surprised by the answers you got from Google either, because really for them to be able to say they're not going to comply with legal requests for information is for them to say, we're going to go to bat for you and violate the law on your behalf, on behalf of users. And I think, you know, that's a really hard stand for them to take. Evan, what do you think about this?
Well, clearly, like you say, they're not going to do anything that doesn't comply with the law. That's in their best interest. Google is a publicly traded company. Twitter might be in a slightly different position in some of the what we would characterize as noble actions it has taken. Obviously in a different context, but still in the general notion of protecting the identity of its users. And I'm thinking about the efforts it made earlier this year, or was that in late 2010 sometime, in response to those law enforcement from the Justice Department requests to get information about certain Twitter users who were associated with WikiLeaks. So, it's easy for us to make these, and this is hearkening back to what I said, in response to the other question you asked me. It's easy for us to get all righteous and expect a bunch of stuff from Google, but Google does not have its users in the first seat of priority when it comes to making all these decisions. It's a for-profit company that has to be answerable to its investors. It wants to maximize its profits, and I think that it's not a direct line from protecting user privacy to serving those interests in profit. And I hate to sound like I'm trying to indict them on all of this stuff, but it's easy for us to have expectations about privacy and demanding that certain privacy be built in by design when we don't really have a good fundamental basis to rely on for that, other than hoping that it will happen and Google will actually just decide to do the right thing. It's we've got to be realistic in what we can expect as users of the system.
Right. It ties in too. I think it illustrates how companies have to make some tough decisions about where they're going to do business and what laws they're going to be subject to, because one could argue that our laws in the United States already give the government plenty of opportunity to go in and gather information about us through backdoors or otherwise, but that other countries are even worse on that front. Iyaz, do you think that that companies can really straddle that fence?
Well, it's about their companies, like Evan was saying, and they're trying to make money. So, we've seen what Google's done with China, and they've taken themselves out of it. We've seen that so many other companies like RIM in India have to try to give up encryption keys that they don't even have so that the government can spy on everyone's communications. When it comes to this whole thing about Google protecting you or not, if there's a valid request and it's actually it's to the letter of the law, they have to follow, otherwise they can't do business in a place like this. So it's kind of it's really strange, but I'm kind of curious about how much they can just get away with by just putting it in the terms of service that nobody ever reads. When you're on a Google property, there's all these things you're agreeing to all the time. So it's just really what they want to disclose, I think.
Right. Dan, if you could constructively assist Google in addressing this conundrum, what would you like to see them do?
I'm not sure what they can do. I think it would be helpful for them to be very clear with the users what the possible privacy issues are going to be. To say, if we get a request like this, we're going to turn your stuff over. We're going to, for example, if they are participating in the so-called CALIA program, which essentially is real-time backdoor wiretapping of communications, then I think they should just say so. I think they should tell people what they're doing, and then people can make their own choices. Ideally, what a lot of people need, and I think this applies in particular to dissidents in dictatorships, who I hope are not being fooled into using things that are putting their lives at risk. We need services, probably things that we'll have to pay for, that provide end-to-end encryption and real security of conversations for all of the issues that will raise about the bad guys using the same stuff, but they're already using pretty good encryption on end-to-end basis anyway. So I'd like to see something like this made available to the good guys too.
Right. Anna, any thoughts before we move on to related privacy topics?
Actually, I don't have any more particular thoughts on this one. I'd be happy to move on to the next.
All right. So, Dan, you pinged us this morning with a story on Boing Boing about data retention, which, you know, if they're going to be recording these sorts of things, we're now starting to get some moves in Congress for how long that stuff, giving some certainty, how long that must be maintained. You want to tell us about that one?
Well, the Judiciary Committee in the House of Representatives passed a bill and sent it on to the full House that would basically order ISPs of all kinds to retain user data for a year and to make it available to government agencies, law enforcement that request it. I'm one of a lot of people who consider this a very dangerous proposal and one that will be a severe constraint on people's privacy and essentially our freedom in the future if this passes the full Congress, which I certainly hope it won't. We are, I think it's just horrible. The idea that the government should have access to every conversation we've had. The equivalent in the real world would be that we'd all have to essentially wear a wire and record everything we say and do in our offline lives. It's very much saying that, and I just think it's outrageous that they're doing it. And what's next? Are they going to order the phone companies to record all of our phone calls for the possibility that a law enforcement agency, and you can bet later on Hollywood and the copyright cartel will want access to this stuff to track down people they don't like. This is quite dangerous in my opinion.
Right. Just, you know, search engine caches are bad enough. This takes it to a whole new level. And is quite a departure from what we see today. Evan, what do you think about at least having some certainty as to what is to be done with data? That's something that's kind of all over the map at this point.
Yeah, well, I mean, certainty is always good, and I can address that in a second for sure. But I guess what I want to do is take a little bit of issue with our description thus far in this conversation of what this bill really calls for. In particular, I have a bit of trouble with Dan's analogy of saying that this would be like having us, or, you know, what would be the next step, having us, you know, record all of our conversations or recording all of our phone calls, because this bill amends just one subsection of the Stored Communications Act that pertains to account information. And in the Stored Communications Act, there's a very well-perceived distinction, a bright line distinction between account information and the contents of communications. And this amendment does not pertain to the contents of communication. This does not legislate the creation of some big database in the sky like the Akashic Records that has, you know, every single word that we say over a Skype call, or every the keystroke that we make. And that's, you know, Cory Doctorow is overstating it in his Boing Boing piece as well. This has to do with account information, and it's the network addresses of internet users that needs to be retained for an 18-month period. So at least what this is mandating that information be kept for 3 times as long as what it already is by major internet service providers like Comcast. Comcast keeps your IP address, the records pertaining to that, for 6 months now. So we're just going to be extending it on there. So I guess my the biggest point that I would want to make in all this is, let's not play Chicken Little so quickly and say the sky is falling and that the Congress, those who aren't working on the debt problem, are in the secret stealing away all of our civil liberties, we're being blindsided. That's not what's happening. If you read the bill very closely, it's much more constrained than what most of the commentary is out there on it. So I think I've made my point on that. Certainty definitely is a good thing, and that's what you asked me about. And it would be nice to know, what information is being kept. But when was the last time anybody called up their or even contacted their internet service provider in any way and asked what kind of information is being retained about them? Maybe there's one person out of 1,000 who actually is proactive on those types of things. If we're going to actually legitimately be worried about those things in the legislative process when we're seeing bills go through here, then let's walk the walk and not just talk the talk, and actually be concerned about these things in the rubric of where we are now, which is only subject to the caprices of private industry. How long does Comcast want to keep this stuff around? It doesn't have to keep it around for any prescribed period of time. I would think that we want to adjust our norms and adjust our sensibilities to really be concerned about that before we get all upset when we start seeing bills just make it through the Judiciary Committee, which means that this law does have a long way to go before the president would sign it, by the way. So that's my take on it.
Right. I like the idea of giving both users an understanding of how long their data and what kind of data is going to be retained, and also of giving the companies who are in this business some framework, because I think they've been, having to take shots in the dark up till now as to what's going to be sufficient to fulfill their legal obligations and what's going to be sufficient to fulfill their moral responsibilities to their users. Anna, do you have any insights here?
I do. What I kept thinking when Evan was talking, I was also thinking about something that Iyaz said earlier, was how much does the general public actually know about what is being stored by anyone, anywhere on the internet? I, for one, don't know most of what's being stored. And so I agree that we should somehow be able to educate the public about what exactly is being stored, what the impact of that is, not just what it is, but what does that mean? What can people do? For example, what can the government do with that information? What can the internet service providers do with it? Who else has access to it? And I think part of that education could be, these are things that are automatically stored in the same way that if you, to be really old-fashioned, went to a store and bought a package of paper and a pen, there would be a receipt saying that you did that. That doesn't mean that they're going to capture the information that's being, put on that. But also, again, to work with the companies in regulating how that's worked. Those were the two things that came to me.
See, I've always been curious about the whole education of the consumer thing, because that's why we have all these EULAs and labels and things that people just have learned to ignore. Yeah. So how many people, when they get a cell phone, it's stapled to the back of it. You have your contract that nobody reads. Look, you're going to go to arbitration now. You have no rights. It's kind of, I don't know how it's even possible unless they flashed it every time you opened your computer. It said, hey, look, this is the data that's being stored. On top of that, people would start just opening their computer and walking away and come back. So I don't know what it would take for people to actually know what exactly is going on in the back end.
Well, Zynga has Privacyville.
Oh, that's right. If they gamify it and you win badges, apparently people will care. I think that's kind of strange.
The other thing I guess I should specify is not that I think that it's the ISP provider or the government or anybody's specific job to educate the public, but it's the public's job to educate themselves.
That would be great.
And that's what I guess I should have specified that when I said earlier, it wasn't that I think that we need to teach people like they're small children, but that the public in general needs to kind of take a responsibility for wanting to learn before they throw big fits about what's being done.
Back to this particular bill, if Comcast and other ISPs have to maintain just giant logs of information, they're going to fight this too. They don't want to do this business-wise because they actually have to put in time and effort into keeping track of all this stuff. So if anything, when they see 18 months, they're going to be irritated. They want it to be like 6 or 5 or none. They don't, to keep track of where your actual your subscribers are, that's one thing. But to keep this for a long term, this is just going to irritate them. So I'm imagining some pretty powerful lobbyists are going to be fighting this anyway. So while it makes them sound like they're good guys, they're helping themselves at the end of the day.
Right. Well, in a moment here, I want to talk about crime and punishment a bit. But before we get there, I'd like to thank our sponsor for this show, which is Netflix. which streams thousands of TV episodes and movies directly to you instantly, which means you save time, money, and hassle. There are several easy ways to instantly access streaming movies and TV shows with Netflix. You can watch Netflix movies and TV shows on your Mac or your PC or your iPad, and the iPad app is really, really nice. I've been traveling all this week, and it has been a nice travel companion on the road. You can watch on your iPhone and some Android phones too. If you have a gaming console, an Xbox 360, a PS3, or a Nintendo Wii, you can watch Netflix right on your TV. And you can do that too if you're not a gamer by having an Apple TV box or a Roku box, a Google TV box. Lots and lots of DVD players have the Netflix software built right in. They're very inexpensive and easy to use. With Netflix, you can watch movies and TV shows instantly using any of these devices, and you can begin watching a movie or show on one device and then finish on a different one, which is really, really nice if you, again, are moving around a lot or simply moving around within your own home. Whichever ways you choose to access Netflix, you can watch as many movies and TV shows as you want, anytime you want, and you can cancel at any time. So I know that most of the people who listen to our show are probably already using Netflix. If you are, that's great for you. If you're not, why not try and encourage a friend or a family member to give it a try, because it's really such a great service, and you can give them 30 days for free if you go to netflix.com/twit. netflix.com/twit. Thank you so much, Netflix, for helping us bring you This Week in Law. All right, folks, if you have been paying attention at all online this week, you have heard something about Aaron Schwartz, who has been indicted under various federal charges for activities relating to the JSTOR research database, where Aaron essentially hooked up a laptop computer to the student educational network at MIT and began offloading a bunch of data that he otherwise had access to because he was a part of that educational community. But I guess the real issue here that led to the indictment was the amount of data and the way it was gathered, and perhaps the purposes to which Aaron is alleged to have meant to put that data after the fact. He wanted to liberate it from the for-pay, limited access JSTOR archive, and because it was public domain data, make it free for all. What I think is really interesting here is that JSTOR really doesn't have much of a problem with what went on. They got the hard drives back that the data had been loaded onto and said, we're done, you know, that's all we wanted. But federal prosecutors are moving forward under, among other things, the Computer Fraud and Abuse Act. And the whole thing is reminding me a bit of the whole Lori Drew case that we had a while back concerning the woman who impersonated someone on Facebook, and unfortunately a suicide was involved in the outcome there, and folks got very riled up, and she was federally prosecuted under the Computer Fraud and Abuse Act. Is it appropriate, Evan, do you think, to charge Aaron Schwartz under that statute simply because he violated JSTOR's, essentially its user policies?
Well, that's definitely problematic, and that's one of that problematic nature is one of the reasons why the judge in the Lori Drew case eventually held that she should be acquitted of what the jury had found her guilty for under violating the Computer Fraud and Abuse Act. And what's going on here, I mean, just to make sure we know what we're talking about here, you've got these and with Lori Drew, was it Facebook? I thought it was MySpace.
It might have been MySpace.
Account. It seems much more MySpacey, doesn't it? You know, where she had set up a bogus account in violation of the service's terms and conditions. And so the Computer Fraud and Abuse Act, it's the federal anti-hacking statute that has both criminal and civil penalties to it. You know, the feds charged her with violating that, saying that she accessed the computer system without authorization, and that without authorization was all dependent upon the fact that she had done it in excess of, you know, what the scope of the terms of service provided. And so it's obvious what the problematic nature of that is, and the judge talked about this in Lori Drew, was, you know, that makes everybody a criminal, essentially. And I can't remember if this was actually something that the judge said, or if it's something that we talked about here on the show, or if it was just in kind of the commentary like this. But interestingly enough, it relates back to this concern, this interest that we have in speaking pseudonymously, however that word is pronounced, on the internet. You know, technically it would be a violation of the terms of service to sign up for, you know, MySpace or Facebook, not using your real name, or, you know, if that's what we conclude that the Google Plus terms require that you use your real name. So, I mean, isn't that crazy to think that you're committing a crime, a federal crime that could get you charged by the feds if you're using a false name? I mean, obviously with this kid, Schwartz, is that his name?
Yep.
Yeah, Schwartz.
Aaron Schwartz.
Schwartz. The Schwartz is with him. You know, obviously with in this situation, you know, he's doing a little bit more than just signing up for a bogus MySpace account. Not to, you know, try to minimize what Lori Drew did, and that's obviously bad, because the theory is that she caused this poor girl to commit suicide. Schwartz here, depending on how you look at it, it's worse. Because of, you know, the grand scale of it, and the brazen nature. It actually involved, you know, getting, you know, actually doing some physical trespass of some things here. But at best, it underscores the weirdness of a Computer Fraud and Abuse Act prosecution, which, and it was, you know, is enacted like so many of these other problematic statutes in the mid '80s. You know, to handle it was enacted really to handle hacking and the unauthorized access from afar, and just like really seems stuff in conduct of a different nature rather than just violating terms of service. So what Schwartz's situation here does is underscore that problematic nature of it, in my mind.
Yeah, the whole thing, you know, I could see that there are all kinds of ways to go after Aaron here. Because arguably he trespassed, he clandestinely accessed the network for an unauthorized purpose. You know, he was, if you read there's a good threat level piece on how he was arrested and how they discovered him, had the laptop concealed under a cardboard box in a closet. You know, clearly he knew he was doing something that he wasn't authorized to do, and that was a bit nefarious. But I do, so he's maybe not the greatest test case for this discussion that I'm trying to have, but I'm worried about everything becoming a computer crime in this day and age. That, you know, we're all toting around phones that could be classified as computers. We're, you know, moving in toward an era of the singularity, where technology is going to be more and more a part of people's lives in various ways. And, you know, as that happens, does everything become a federal computer crime? Dan, does this worry you?
It worries me a lot. The idea that a terms of service violation is 35 years in prison is pretty scary.
Yeah.
And the real culprits in this, you know, are Congress, which continue to refuse to do their jobs in all kinds of ways. But this is just one more case where they've enacted laws that are sufficiently vague that overreaching prosecutors will happily take advantage of. And this is going to be an ongoing thing. But the fact is, everyone on this program is probably a criminal according to the law for something we've done in violating a terms of service. And that is discretion that should be frightening to people.
Yes, Soviet Russia comes to mind. Iyaz, any thoughts?
Yeah, I mean, we talk about this a lot on Tech News today. I mean, there's a lot of laws that seem to be just incongruent with what's actually the reality right now. Stuff was written a long time ago, and it's a lot of interpretation has to be done in court cases instead of just rewriting the law at this point. I think a lot of things just need to be examined and go, okay, look, this is not the case. I mean, every law out there isn't the Constitution. We have to interpret it. We can change some of this stuff. Like if this law was written in the 80s and everything is a computer, let's change it. So I mean, it's a very slow progress, as I've seen in a lot of the news stories, that the law won't change quick enough to keep up with technology, because technology is changing so fast.
Anna, you have a technology-oriented practice. Do computer crime issues begin to creep into your civil matters?
You know, Denise, I haven't seen any so far in my practice. And what I was thinking when Iyaz was speaking was that I'm sure I probably learned this somewhere in law school, but I've definitely seen this in practice, that laws didn't come about to provide a framework within which we should operate. They came about as a result of somebody either needing to be punished or somebody getting upset because someone did something to their personal property or life or, you know, etc. And so as a result, our laws are, I think, always going to be incongruent with what is actually happening, especially in the field of technology, as it develops so quickly and there's just no possible way that they can keep up.
Yep. Well, there's a really interesting article I would point people toward over at law.com. It's by Ken Struton, and it's called What Changing Definitions of Computer Mean for Criminal Law. And for anyone interested in this topic, he poses some really interesting questions and sort of sets the stage for a discussion of will everything be a cybercrime in a matter of just a few years. So food for thought there. Turning to the other thing that lots of people run afoul of in intellectual property law, the more and more we use technology. Really interesting issue that we haven't discussed before on the show comes up with the notion of 3D printing. This is something that I haven't followed all that closely. But as I understand it, we are approaching technology that is good enough to enable you, once you have the CAD designs, to duplicate an object in 3 dimensions in a very high fidelity way. And of course, immediately when you have, you know, a tea set that costs hundreds of dollars and you can duplicate it for $25, folks might want to go for the $25 model. And so we're considering whether 3D printing is the Napsterization of the manufacturing world. And there's a good piece at CNN about this by Peter Hanna. Iyaz, what do you think of the ramifications of 3D printing on intellectual property?
Well, I mean, I think first on the CNN piece, calling it the Napster manufacturing a little bit misleading. I mean, it's more like when the printing, you can print your own stuff. That's not necessarily evil. It's just you're doing it that way. I think that it's going to actually open up a pretty good market, actually, not just for the illegal files that are going to be around, but I can imagine Amazon selling you the exact CAD file that you need from GE because they made your dishwasher and you have this extra piece that you need. Mm-hmm. So I'm actually very curious about how many different pieces of IP law apply to this, because you have the actual documents and designs and then the actual object, and can you reverse engineer things, and is this illegal? So like we're going to be running into like everything at once is going to go together. We have copyright and we have patent law, and I guess trade secrets could also be implicated in this. So like it's really interesting to me to see all of it collide with one simple thing, because you can actually print out this stuff now. There's something called, I think, the MakerBot, and you can, these aren't like tremendous, like you can't just make a chair or something. I mean, it just builds, you know, layer by layer in plastic, and if you wanted to and you wanted to go further with it, you can make a mold and then cast that. I know that Jay Leno does that for car parts. I mean, it can be done. I'm intrigued to see where this is going to go, but I'm pretty sure that there's going to be a lot of litigation on this one.
Right. Well, I think we have some images here, and now I get to actually just sort of wave at Burke across the studio, and he can either switch things to my computer or he can put them up, whichever works best. You want to switch to me? But I do have some visual aids to help us consider what you can do. And a chair is one of them. There is this product, a Chippendale-style chair that you can get from the 3D Studio, which is one of these 3D printing clearinghouses where you can get these products, that looks very, very much like a chair that you can buy for $700 at Neiman Marcus. And if we can't get the images, that's fine. We're feeling our way here along in the new studio. But it's pretty interesting stuff. Evan, what do you think about intellectual property, trademark, copyright being infringed in three-dimensional space?
Iyaz is right. I think we should expect a lot of litigation to come about from this, just because it literally is adding another dimension to this and giving us a new, opening up a new set of types of scenarios to think about, where there could be copying or practicing of art, to use the patent nomenclature and all of this. So definitely there will be some disputes. I would urge that we be conservative in our thoughts or motives to want to rewrite the intellectual property laws in light of all this. And now, don't get me wrong here. Make no mistake. I am not suggesting that the Copyright Act and the Patent Act and some of the portions of the Trademark Act, I'm not trying to suggest that they don't need rewritten. But this necessarily is not the catalyst the main catalyst to be driving intellectual property reform. And the reason I'm saying that we need to be conservative here is because I think we have a lot of principles already in place in intellectual property law to help us through the analysis of what's going on here. Say, we were talking about this chair, and you can download a file and then have this this three-dimensional object made. Voila, here's a chair. Now, what that is really, at the most fundamental level, and I don't want to argue too much about semantics or make too many, invite too many distinctions to be made here. But what we're really having is downloading a set of instructions so that it can be, rendered in 3 dimensions. At a certain very fundamental level, that's the same as downloading a digital file and having it rendered in 2 dimensions, especially if we're talking in the world of copyright with creative works like that. Or, a music file. I don't know what dimension that would be in. A music file is not really a 2-dimensional, a song is not really a 2-dimensional thing, but it's more, it maps closer to a 2-dimensional object in this situation than it does a 3-dimensional object. So when you download an MP3 file, you're an infringer whether you actually listen to the song or not. And so the connection I'm trying to make is you're an infringer having downloaded that file just like you would be conceptually. I would suggest that it wouldn't be too much of an analogical leap to make that you would be an infringer just by having the file, whether you were even going to be creating it here. So there will be litigation. There are plenty of things to talk about here, but we already have a lot of things that are helpful in the way that intellectual property law has shaped out in the digital age thus far to make it so that we're not completely operating in the dark when we're thinking about these inevitable disputes and how they should be resolved.
So Peter Hanna, this Jenner and Block associate who submitted this item to CNN, had an interesting observation and posited that our entire body of copyright law sprung up in response to the Gutenberg Bible and the printing press. And he wonders whether a whole new kind of intellectual property protection is going to have to spring up around the notion of reproducing things in the real world. What do you think of that one, Anna?
I agree. And one of the things that I think, personally, maybe because I love trademark law so much, but that was the first thing to strike me was, what is this going to do to trademark law? Mm-hmm. What is this going to do for big brand owners? I don't remember who you said the brand of that chair was, but let's say, I had a good friend of mine, her aunt has Kate Spade wine glasses. Mm-hmm. Now, if I were able to go over to her house for a dinner party and be like, oh, I love these wine glasses, can I just, scan the design in and then I can have my own set? Mm-hmm. And then I go around announcing these are my new Kate Spade wine glasses. The implications on trademark law are fairly obvious there. But one thing that I think could go in favor of the trademark holders is the quality of the goods. And obviously that will be something that develops more as these printers develop and the technology behind them develops. But, for now, if they're made out of plastic or, some, shall I say, lesser quality material, then, that the goodwill behind that name could be compromised by those. But the brand owners still have a a good market for the actual brand, much in the same way that now we have knockoff, you know, Chanel purses, but Chanel would say our product is better because it's actually ours.
Right. So the Neiman Marcus ad for this chair points out sort of an interesting conundrum because, okay, there's the 3D chair that one can print, and it's very close to what's available on the Neiman Marcus site for $699, which is from their Jonathan Adler collection. But it, of course, is a Chippendale side chair, right? So the branding on that goes back to Chippendale and the rights that you would have in that ancient brand. Iyaz, any thoughts?
Well, I mean, back to what Anna was saying. I mean, you can make knockoffs now. I mean, and we have counterfeit laws, and we have things that deal with that kind of thing. The idea that people in their house can make things faster, I don't know if that's necessarily going to be. Everyone's going to just do it themselves. I don't know if that's going to be the situation. It's not like people are printing books and then in their house, I'm just going to staple it. People still like getting either ebooks or a real book because it's bound properly. There's certain things that you might not be able to do at home. I mean, the stuff we're seeing right now is really kind of in its infancy. I mean, it's gotten to the point where it's cheap enough that you can have it in your house and you can make little things, but it's not going to be as quick as making that chair because that you do have plans. I mean, you can get plans right now to build this chair, you know, the Dr. Evil chair, I bet. And if you're willing to do the work, you can make it. I mean, you can make this table, you can make anything if you want to. But I don't know if people are just going to go, oh yeah, my printer's so awesome, it can just print out anything. I'm going to have space for everything. I'm going to knock off everything. So I don't know if it's really going to be the, you know, the end of everything. It's just going to be higher quality things. You're going to see a lot more branding, I'd imagine, and maybe even measures to make sure that this is the authentic thing. The printer cannot print this awesome pattern that I have on this desk or this inlay or something like that.
So it's like DRM in the 3 dimensions.
DRM in 3 dimensions. I like that. Well, yeah, because, you know, I've watched a lot of episodes of Star Trek The Next Generation, and at no time did they ever interject that there was litigation against Starfleet from Earl Grey because Captain Picard was ordering up his tea from the replicator. Dan, do you think that we're going to see that at some point down the road?
Sure, we're going to see things like, but how are they going to work against, for example, there's a chair over here. What if I scan it with my phone, an advanced phone a few years from now, that gets a really good 3D scan? Then I haven't downloaded anybody's design spec, so there's no copyright violation there. What are we going to have? Objects that tell devices which obey not to be scanned. Is that where it's going to have to go? That leads down a pretty interesting path.
Yeah, and I've seen an Apple patent on that, on their cameras, on their phones, that theoretically it could identify when it's at a concert and it would deactivate the video recording capabilities. So what you're saying, Dan, could be a real thing. People like, okay, turns off your phone.
Right. Anna, you were going to say something?
I was. No. Oh, yes. It completely escaped me. I remember. I think it could also open the door for some really interesting licensing options. You know, different pricing tiers, perhaps, or just a different way for brand owners to license their marks and license the trade dress on their products that I think could be beneficial in a lot of ways.
Right. Well, George Lucas sure wishes that they had some 3D DRM they could have applied to Andrew Ainsworth over in the UK, who is the original person who designed and created the armored costumes for the Star Wars series. You know, the Stormtrooper armor, the TIE fighter pilots, everything that has that shiny, plasticky helmet and or bodysuit from the Star Wars films, I think he was involved in when you go to his site. Yes, there we go. There's a nice model, molded Stormtrooper costume. And for a while now, he has been selling costumes at quite a hefty price in the UK from his original molds, on the theory that the copyright for these things in the UK only lasted 15 years, and they've now fallen out of copyright, and he's free to sell them. He was sued by George Lucas and Lucasfilms in the UK, and it turns out he has prevailed. So maybe this is just an anomaly of UK copyright law, which is what the Lucas lawyers have been saying. It seems to me like, I guess henceforth Hollywood won't be going to UK designers to create things like this, since this could happen again. Any thoughts, Iyaz?
Well, I mean, if it was already out of copyright, couldn't anybody make knockoffs or make these replicas anyway? I mean, why was this guy particularly getting hit? Because he made the original? That's what I was.
He had the molds.
Okay, so he could make them exactly the same. So
yes.
So Lucas was going after the fact he was using the original molds. Is that all? Well,
and he could do it. I mean, I think it would probably be not too straightforward to create the molds from scratch.
I mean, I've always looked into the replica prop stuff. I'm a nerd, you know. I like getting those kinds of things. So, like, I mean, it's nice to see that you can get this. But I see what they were going for with Lucas. I mean, if you have created something, or at least this universe effectively, and you want to merchandise everything, because Star Wars. Well, let's see. You can find Star Wars on everything, including Xboxes now. So, I mean, like, the actual Xbox has got an R2-D2 decal on it now, which doesn't make a lot of sense, but it does for Lucas, because it's just merchandising rights, right? That's all he wants.
Right.
I don't know. I mean, I'm kind of glad that this is available and you can get it, but I'm so sick of seeing Star Wars on everything anyway.
What do you think, Evan? 3D DRM would have solved this?
I guess so. You know, there's a lot of effective uses for that, as many as there are scary ones. But I mean, with this one, this just seems like kind of a hyper-technical holding here, and a bit of a Pyrrhic victory for this guy, because as I understand it, you know, this decision from the High Court in the Court of Appeal in the UK didn't change the fact that this was copyright infringement in the U.S. So, you know, okay, fine. There's this holding that's based on this definition of, I think, was it like industrial property or something like that? You know, the commercial aspect in which this was made here. What I had not thought of until you just mentioned it, kind of in passing, a little bit offhand, was how this might have the unintended, or at least the negative consequence against guys in this, the plaintiff, or I guess the defendant, this guy Ainsworth, how it might have a negative impact on the market for these types of designers in the UK because of this shorter period of protection like that. And so wouldn't it be a bit ironic if decisions like this actually hurt the livelihoods of similarly situated people, where, you know, this is being hailed as, oh, it's a victory, oh, I've been victorious, this is liberation, this is freedom, this is, I guess the subtext to that would be, this is stirring innovation, when actually it may actually cause that well to dry up, because who would want to hire a UK designer if the rights aren't going to be as robust for the commissioning party? Seems controversial at least.
Right. I guess the legal fine point was whether it was a sculpture or a costume, and they determined that it was a costume, and therefore had this short copyright period.
That's the stuff that keeps me up at night. I don't know about you, but laying there, sculpture. So.
Yes, exactly. Dan, as long as we're talking about copyright in the UK, you informed us this morning that there was an alleged privacy site that an ISP has been ordered to block. Tell us about that.
Yeah. Well, it's, as reported in the media in the UK, there's a site that has links to, it does not host the allegedly infringing material, but has links to it, that a court in the UK ordered an ISP to stop, a big ISP, British Telecom, to stop letting people go to that site. And, you know, that's raising a lot of alarms among a lot of people, because it's, for many reasons. One is that the infringement, if any, is secondary. It's not direct. Secondly, the idea that we're going to stop, that we're going to order sites not to be seen and have the ISPs be part of the policing of that, it's a trend that we might want to be careful about getting into. And of course, here in the US, the Congress is debating a law that would explicitly permit what the Obama administration is already doing by taking down sites that Hollywood persuades law enforcement are bad sites. So we're heading toward more censorship regimes, and that's one step in that process.
Right. I think it's dangerous to involve courts and legislatures in directing, exactly what can and cannot be online unless there's criminal activity involved. And, that's where we get into copyright being an interesting body of law, because there are criminal penalties that can be associated with it. And the particular legislation in the U.S. seems to be coming and going, and, it's proposed and then it goes away and comes back in a new form, and so far it has not manifested itself, but it's definitely worth watching. Anna, any insights there?
I always think that anything that stifles innovation is a bad idea, and I understand the urge for smaller businesses or individuals to want to take down the big man, but I think that sometimes litigation is not the answer, and what may be considered a win for this particular person is not necessarily a win for everyone, specifically other designers in the UK who may not get business now. But also, I think I read in one of the articles that one of his arguments was that these uniforms were actually functional, and that took them out of being copyrighted material. I'm not sure if that's true or not, but I think that would be very damaging to any kind of artist. I always think there's a fine line between arguing that your art is functional or not. And I know that Iyaz, you were saying that a lot of these things are functional, that, if they're made for a movie or something like that. But in a lot of ways, I think that people should be guarding their IP rights, specifically their copyrights, and not arguing that they're functional just to win this particular case.
Hey, Evan, speaking of scary court orders, how about this write-up of Zimmerman versus Weiss from Venkat Balasubramani, where the court ordered a plaintiff in just a kind of a run-of-the-mill suit, a personal injury case, where evidence about what the person's condition before and after a supposed work-related injury were at issue. And in order to get at some of the evidence, the judge ordered this person to turn over their Facebook and MySpace passwords, which would just enable the defendant in the case to graze through the account. They were cautioned not to change anything while they were there, which I thought was gracious of the judge. Venkat points out that this is, far too broad for what they were trying to get. But it's an interesting conundrum. I mean, the stuff was locked up behind various architectural privacy protections in the social networking service. So that's why the court ordered the passwords turned over. But I think clearly that was an overarching decision. Don't you think so, Evan?
Yeah, I definitely agree that this holding goes too far. I mean, this is the relevant analysis here really focuses on relevancy and privilege and stuff that would be protected from disclosure. Bringing this up again, the Stored Communications Act, Section 2703 of Title 18. It's the federal stuff that gives you privacy protection for your email and stuff like that. So, I mean, in the process of discovery in civil litigation, the whole purpose of discovery is to exchange information between both sides in the lawsuit, so that the evidence, the body of evidence that goes to prove the claims and to support the defenses in the matter, get before the court, and so it lets the litigation actually happen. I mean, this is all about information, really, whether it be in the electronic age or back in the good old days when everything was on paper. So there's no disputing, and no reasonable person these days is going to say that there's not tons of information that we disclose by means of a social media account that could be relevant to a lawsuit. I didn't look too much into the details like this, but I remember some earlier cases that deal with the discoverability of social media electronic evidence. A lot of these are personal injury cases where the issue in the case might be the quality of one's life. You know, was the injury so bad that they can't go to the beach anymore, or that they can't have a meaningful life, and they're not happy, and that they've lost the consortium, you know, and things like that. So, you know, there's that's the very nature of social media, is to share information that could tend to prove those things. So clearly, that type of information may be relevant to the issues in the case. Was this injury so bad that you deserve $5 million? The natural counter tendency to that is this sense of privacy. Wait, I have to log in to, I have to authenticate myself in order to have the access to disclose this information or to delete it or do whatever. So we immediately start thinking of privacy. And the courts have been pretty uniform in their approach to this, is that the notion of privacy in this context is very different than what the law will recognize as privacy. And I know that's touched on here. The privacy settings, the court even talks about how, you know, mostly Facebook, its privacy settings have been the subject of criticism and controversy. What that means is that the idea of what we think of as privacy in the social media context means little or nothing when it comes to the privacy as to whether or not this information should be turned over. The main problem with this holding here is just that it opens up the account, access to the account, to the opposing party, and that's just, there's no question that that's too much. In the brick and mortar world, the analogy in discovery is you don't just allow somebody in and rummage through your file cabinets. There has to be some kind of constraint so that the relevant information, or the information that could be relevant, is separated out. With this, it's problematic because there's going to be all kinds of irrelevant information. Also, when you log into a Facebook account or a MySpace account, you have access to the direct messaging feature, or, you know, the inbox feature. And there's case law out there that says that that's entitled to the same kind of privacy protection under the Stored Communications Act as email. So, you know, you're really essentially forcing a consent to that, which is problematic for privacy concerns. The law recognizes a heightened privacy interest in that kind of stuff. So this case goes too far, but that doesn't mean that there shouldn't be some discovery permitted in people's social media accounts.
Right. Fried Geek in IRC is asking, well, doesn't this implicate the right against self-incrimination? It would in a criminal case, but this is a civil personal injury dispute. So if it's relevant to their state of physical health, then it would be discoverable. It's just the way that it was ordered to be produced in this case, I think, was a bit scary. Any thoughts, Iyaz?
Yeah, I mean, it's a social media case. I mean, the funny thing is, the rule of thumb for me back when I was doing like websites before there were blogs and things, don't put anything online that you don't want on the front page of a newspaper. I know that sounds antiquated now, but you got to be very careful what you put online at all. And if you're going to put stuff on Facebook that could get you in trouble, you shouldn't be sharing it, I guess. I mean, I know it sounds limiting to a lot of users, like, oh, I want to be able to share everything, but you should be aware that this can happen. People can go ahead and take a look at your stuff later on. The other thing is, I'm kind of curious about if this user had a very locked down account. Did they actually go through the steps of, okay, only my friends will see what I'm doing, versus having a public page where people didn't bother to change anything on the privacy settings, and all this stuff could have been accessed anyway. That's just a curiosity about this case I want to find a little bit more about.
Yep. Dan, do you quiver in your boots to think of a court ordering somebody's social media passwords turned over to an opposing litigant?
Nothing surprises me anymore, and the other folks here have covered this pretty well. I think the larger issue over time is going to be whether people's passwords to information that they have stored on their own computers will be whether you'll be required to turn them over, and then longer range whether we're going to be even allowed to store our stuff in an encrypted way that other people can't get to through one way or another.
Right. I guess it all just comes back to exactly the point Iyaz made. You know, if you're putting it online, it's going to come back one way or another. I have a few updates on some cases we've been following that just want to drop on you here. The Google Books case, which is now 6 years old, had some movement recently with a status conference there, and the judge basically threatening both sides with, if you guys don't work this out, I'm going to have to come in and decide what fair use actually is, and wants a decision from them by September 15th on whether or not they're going to be able to settle this thing. Anna, any thoughts on the slowly dragging along Google Books case?
Every case slowly drags along,
yes.
Denise.
This is true.
Could I know that you probably want to move this along, but I just had a comment about what we were just speaking on. And one thing that Evan said about the protection for chats in Facebook being equal to those in email, I'm curious if that's why Facebook, do you remember Facebook used to let you chat, and now everything is messaging and chat all together? And I wonder if that was any of the impetus for them to change that. Just a thought I had. But one of the other things that I was thinking was, I'm so sorry. I was up until really late last night finishing up my brief that's due today, so I apologize that.
That's okay. You're right in there with all our engineers in the studio who have been basically operating on about 3 hours sleep for the whole week.
Thanks for being generous.
Alrighty, so yes, I think that's an excellent point, and I don't know the answer to your question about Facebook chat, but it's worth considering. So the other interesting thing about the Google Books settlement is it's rumored that Google may be reneging on its stance that people could opt into being in the program. That's been a big sticking point as they move along, that whether people should have to affirmatively opt out of being included or whether they could opt in. And an opt-in settlement is being rumored to be on the table, so we'll watch that. Also interesting this week has been the Oracle versus Google patent case, which has just had a lot of procedural stuff going on that I thought we'd encapsulate. Larry Page's deposition has been ordered. Pretty interesting there to see someone in that position ordered to be deposed. I guess in a case like this, it's not too surprising, and it's been limited as to subject matter. Have you been covering this on Tech News Today?
Yeah, we've been covering this. A lot of stuff's been coming up, like the CEO of Sun back when Android was introduced was like, congratulations, good luck with everything. And
right.
if they weren't mad then, why is Oracle suing now about the same patent since Oracle bought Sun? We've been on top of this for a while now. But these guys have been going back and forth. This also seems like it's dragging along too. Oracle and Google.
Well, they've finally gotten a trial date. That's going to be right around Halloween. And they had some damages motions pending, an expert report that seems like the judge did not like on the basis of Daubert, which is a way of questioning the reliability of what's being submitted to the court. The judge there also, let's see, we looked up his name. He is Judge... Alsup, exactly. Had some great comments for the parties about not being a wholly owned subsidiary of Oracle.
Okay, he's also the same judge who did say to both of them, you're both asking for the moon. You have to be reasonable in your requests.
Exactly. I think that point about these estoppel arguments that are being made, apparently Larry Ellison made a bunch of sort of Android welcoming comments too, that while they look good in a headline or in a piece about the case, I don't think they're all that damaging when you get into the nuts and bolts of this thing. I mean, you'd basically have to show that when those comments were made, all these Oracle representatives or Sun representatives knew exactly how Java was being implemented in Android, and I don't think they had done that analysis at that point.
There was another piece of news that came out. I think it actually got cut from the show the other day. It was there were Google emails, basically knowing that they would either have to work with son to get the rights to the patents, or they would have to go and make enemies, I think was the phrase, and just go at it on their own, which was kind of an interesting idea. I don't know what exactly they're going to use that piece for.
Right. And then finally another case, the fellow Paul Ciglia, who thinks he owns half of Facebook. The man just can't seem to get himself a lawyer, though.
Yeah, the report is that his fourth law firm has withdrawn from representing him.
Right.
And of course, I mean, the headlines have to write, withdrawn, but we kind of know why that would be happening. You read the stuff in your ethics class, and you're like, well, you withdraw when you know your client's completely out of his mind or something like that. Well, actually, he could be out of his mind and still have a deal, but I'm getting off the point. It looks like he doesn't have a case then. If 4 law firms, I mean, when DLA Piper took the case, it looked like a really big deal. Like, okay, if they're taking him up, he must have something, but they dropped him. And so this is I think he's on to his 5th attorney now. So good luck with that.
Yeah.
And your half ownership of Facebook.
I don't know. Yeah, just on a contingency basis, it seems like anyone would want to jump in and take that on. Joe Mullen over at Paid Content says it seems to suggest that whatever these firms are seeing when they go through Ciglia's evidence, they don't like it. On top of that, a month of searching hasn't led a new law firm to join up with Ciglia's team as counsel of record.
He's just representing himself at this point, I think. Maybe he believes himself.
Exactly. All right, so I have a tip of the week and a resource of the week for us. Our resource first is a very useful article over at law.com. For those of you who are not actually in the legal profession, I should share with you that our saviors in the legal profession are our law librarians who know how to put their hands on all manner of information in the most cost-effective manner possible. And Louis C. Abramowitz has written a great article over at law.com called Cost-Effective Web Tools for Business Intelligence. And I throw that out to our audience because these are things that just about anybody could find useful for digging things up that are free, and it's without using any backdoors or court orders or subpoena powers. It does cast a light on the fact that there's a lot of information that you can gather about people for free and in a perfectly legal manner that maybe people aren't aware of, and it's worth perusing this list for that reason only. But there are public records databases here, such as Open Secrets, Pipple. Pipple is the most comprehensive people search engine, so they say. Various ways of getting at legal information and public records information, cost-effective web tools for business. Also, our tip of the week, it comes to us courtesy of China, and an article at VentureBeat profiling a company there called Xunlai, if I'm pronouncing it right, Xunlai Limited. And it is a classic Napster kind of company. And just when you thought that those sorts of folks had been driven out of business by the MPAA and RIAA, comes Xunlai on the scene, roaring forward toward a NASDAQ IPO. And so I guess our tip of the week is, if you're clinging to your Grokster-esque business model, locate yourself in China and then try and raise funds from U.S. taxpayers on the NASDAQ. Because although these folks have been sued in China numerous times, and the entertainment industry has certainly been trying to curtail their activities, they are winning over and over again in the Chinese courts. And as I said, running up toward their IPO here, triggering the question, should U.S. investors be allowed to fund this kind of business? What do you think, Evan?
Sure. I mean, if you want to take the risk of it backfiring and there, being a change in the law, China comes to its senses and realize it needs to join the rest of the industrialized world and not have such a renegade attitude toward intellectual property. If you want to invest your resources in something that's based on that, go right ahead. I don't think we need the government to tell us that we shouldn't be able to put our resources wherever we want them in that regard.
Right. We have a 10-year anniversary I don't want to let go by without acknowledging via Evan Prodromou. Someone I follow on Google Plus, who is a great person to follow, but with a last name I'm just going to not even try and butcher any further, pointed out it's been 10 years since Dmitry Skylarov was arrested for violating the DMCA, yet another civil statute that has criminal aspects to it, and was the first person ever prosecuted under that. And ultimately, it was not Dmitry who was held responsible, and he was allowed to go free. And ultimately, I think even Elcomsoft, his company that was breaking the DRM on ebooks, also got off the hook, because they were Russian-based, basically. So 10 years since that very high-profile case. Dan, you remember that one.
I remember it somewhat. It's been a while now, but it was an interesting case for a lot of reasons, because it was breaking really new ground. And I didn't recall that it was because it was in Russia, but that I remember mostly that it looked like prosecutors reaching way past what U.S. law said, but I don't remember the details.
Right. The precipitous event was Dmitry's appearance at the DEF CON conclave in Nevada and giving a seminar on ebook encryption, and then the feds came after him. So interesting anniversary to note. And with that, I'll just go around the table, see if anybody has any final thoughts. Evan?
Oh, wow. First, no, I mean, this is a great conversation. It's been fun having 5 people, or wait, how many people are there? 5? Are there 5 of us? Right? There's more
5,
than usual,
yes.
Right? There you are. Yeah, great conversation, Dan. It's always great to talk with you. I have so much respect for your work. So really, always an honor to get to talk with you. Anna, great to talk with you. Iyaz, glad we can all catch up. So thanks for having me, Denise. Really a pleasure.
Our pleasure. And folks, you can follow Evan at Internet Cases on Twitter, and his blog is internetcases.com. And when he's not joining us here on TWiL, he's practicing law at Hinshaw and Culbertson in Chicago. Thanks, Evan.
Thank you.
Anna, thanks so much for joining us again today.
Thanks, Denise. It was a pleasure speaking with you and Evan again, and Dan and Iyaz. It was a pleasure for the first time. I really appreciate the opportunity to come see your beautiful new studio. I appreciate it. And thanks to everyone who listened to me last time, episode 119. A small update on my case, Apple Inc. versus Sector Labs. I'm filing my trial brief on the merits today for the defendant. I do have a docket. I don't know the website for it, but if you want to go to the USPTO under the TTAB, you can search for Sector Labs and you'll find it. If you're a huge law nerd and you want to read my brief, I think it's like 40 pages long, so I won't blame you if you don't. But thank you for everyone who helped me with that, my wife especially. And thanks for letting me be on the show again.
Sure, it's a pleasure. That was our There Is No I in Pod case. And we're looking forward to having you update us as that one unfolds. Iyaz, great to join you in studio today.
Thanks for having me on the show. I mean, it's great to just talk about law and to be in the company of you folks who know so much more than I do on this stuff. It's just great to get that perspective. So thanks for having me on, and thanks for coming in.
It's a pleasure. It's great to check out the new digs and enjoy the amazing state-of-the-art setup here in lovely Petaluma. Yes, and it's fun to participate in ironing out the kinks as well.
There you go.
And Dan, it's always a pleasure to speak with you.
It's huge fun, and as usual, I learn much more from the rest of you than you could possibly be learning from me. So that's always much more fun. I like being the stupidest person on the panel. That's always a pleasure.
Dan, I've been following you primarily on Google Plus during the last month, and happy 1 month anniversary to Google Plus. But you're involved in so many things online. Why don't you bring us up to speed on what you've been up to lately and where folks can find you?
Okay, I'll try to make it brief. I'm teaching part-time at the Cronkite School at Arizona State University and working on entrepreneurship with students. I'm still doing a blog at my own site and on a site called mediactive.com, which is a site for my newest book, which is a book plus lots of online stuff project. And writing a weekly column that's in Guardian Online, the London Guardian, and lots of other stuff, but those are the highlights.
No books in the works?
I'm doing version 2 of the current of Mediactive, actually. That is, I hope, will be out later on this year. And version 1 of it was just published, in fact, this week in Japan.
Wonderful. Well, we look forward to that, and I really appreciate your joining us today.
Thanks.
Take care. And thanks, everyone, for joining us live. We record this show live every Friday at 11 o'clock Pacific, 1800 UTC at live.twit.tv. Or if you would rather pick up the show after the fact, we're distributed in iTunes and on YouTube and on Roku and on various MediaFly outlets. So we appreciate you tuning in however you do. You can visit our Facebook page between the shows at facebook.com/thisweekinlaw. You can follow me on Twitter. I'm at @dhowell. You can email me anytime, Denise@twit.tv, with your questions and suggestions for the show. We love to hear from you, and we love being here in the studio. We'll talk to you again soon. Take care.